Now this dream continued haunting me, and I had to tell someone. So I went and told my mother, and she said, "Let me tell you, son. Your great-grandfather was an
So there you
Indian
go.
chief
It is
of
September
a tribe
18th.
called
Welcome to Let's Talk Native on the LTN Radio Network. This program breaks all the
I
rules
was
for Native radio. No
a
buffalo speeches,
survivor
no mystic
of
healing,
this
no
Indian
special Indian prayers. We tackle the real issues facing Native people. We look back at our glorious and our grave history, a tough look at where we're at now, and a look forward to our ongoing battles for sovereignty and autonomy. Let's Talk Native is produced in association with Iroquois Promotions on the LTN Radio Network, streaming live from the Cattaraugus Territory and simulcast on the Gwe at CKWE in Tendanega. You can find us streaming live at www.ltnradionet.com. And of course, we are streaming live on Facebook Live. So you can get the audio and the video, and we can look at your comments if you dare to do so. I'm John Kane. I'm your show's host and producer, and I've got Jake Proud in studio, who's running the cameras for our Facebook live stream and for what will ultimately be our 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 put placed on our Let's Talk Native uh, TV channel on YouTube. So my thanks for Jake for putting that together. Um, our studio engineer is Kelly McMillan, and I thank her for her fine work in putting our setup together. Hey, that opening song, I used to play that song as my intro. That was my intro early on when I first started doing Let's Talk Native, and it's actually that's my wife's uncle who put that piece together. It's kind of a timely song because we've talked so much about casinos and what it means. It's a bit of a a skeptical view of casinos and perhaps some of that warrants skepticism, especially when you look at how the state has been trying to take over certain portions of revenue. So anyway, that's Casino Dreams. Look, I'm going to spend this hour talking about the UN Declaration on the Rights of Indigenous Peoples. The anniversary of the passage of that was 10 years ago last week, and so I think revisiting it 10 years after the fact, recounting a little bit of the history, so people understand just how it came to be. It didn't happen without a scrap, without a fight, and I think there's language in what we call the DRIP, the Declaration on the Rights of Indigenous Peoples. There is language that is worth noting. It's a language that I cite all the time, but I want to talk about um, perhaps perhaps some of its shortcomings, but also our shortcomings in utilizing this international document. It's a declaration. It has been approved by the entire United Nations Assembly. I mean, when it was voted upon, it passed with only 4 no votes in 2007. Um, Ironically, those 4 no votes were Canada, U.S., Australia, and New Zealand. But since then, those countries kind of came around, and we'll talk a little bit about that and what that means. But there's language and there's certain things in here that are really relevant to everything. They're relevant to our battles over pipelines, our battles over land resources, our battles over what businesses we can participate in, how we can participate in those businesses. There's language in here that protects us that's supposed to protect us from genocide, and of course the shortcoming of a UN declaration is okay. There's the bark, but where's the bite? And I think this tends to be part of the challenge for the United Nations, especially when countries like the United States, who have veto power, they have so much control over what the United Nations does that it's hard for the United Nations as an institution to take much in the way of any action against the United States. But even countries that don't have that kind of power, like Canada, for instance, Canada is every bit as guilty of as the United States, and I think that's part of the reason that why the United States also would be very, very apprehensive in signing off on any of the condemnation that comes out of the UN for Canada. In fact, recently there have been a couple of reports, especially reports on the convention to end all forms of racial discrimination, has held that Canada's record on this is terrible. But I don't know how you can look at Canada's record on it without necessarily condemning the United States. So I'm going to go through this thing. I've got a copy of it here, and so there's a few passages that I think are noteworthy, and then there's things that are not written in here that matter. But first, let me get back to the vote on this thing. So in 2007, when this thing was put to vote, like I said, 4 countries voted against it, and those 4 countries, ironically, and by no coincidence, have a fairly recognizable indigenous population, even if our numbers are somewhat diminished through genocide and any number of other atrocities that have been committed by not just those 4 countries, but frankly the parents of those 4 countries. So when you think about the United States, in fact, the parent of all 4 of those countries is Great Britain. And so when you think about the atrocities that were committed against Native people, it wouldn't just be Great Britain as a powerhouse in Europe, but other European nations like Spain, France, Dutch, Germany. I mean, any number of Portugal. These are all countries that had asserted their uh, desire to build empires and colonization, if you will. And of course, we've talked about things like Columbus, his voyage, and how what he did in 1492 has been mischaracterized in such a way that that even little children are taught to believe that somehow Columbus landing here, which he didn't do, but landing on the Isles of Espanol or in the Caribbean, that somehow gave him lawful right to claim lands for European countries. So I'll start right there because this part of the whole Columbus, John Cabot, any of these guys, Amerigo Vespucci, all these guys, any of these ones who had sailed for Spain or Britain or Portugal and laid claim to lands in the Western Hemisphere, they did so based on the doctrine of Christian discovery. And the doctrine of Christian discovery is basically a church policy that was born out of the 15th century that said if the Christian nations of Europe should discover lands not currently or currently unknown to them that had pagans on them, that they could take the land. Not only could they take the land, but they could take the people. They could make slaves out of them. They could take their possessions. They could do all of those things. And essentially, just by virtue of being a Christian nation of Europe, it gave them certain entitlement to lay claim to the title of land. The fact that Native people lived in these places, whether it's Australia or New Zealand or North or South America, was didn't matter. And in fact, according to the church, those beings, those people, could be treated as less than people. In fact, the expression that came out of the church was they called it terra nullius, which meant that it was land void of humanity, that there were no people. Terra meaning land, nullus meaning void. There were no people there. So it was vacant lands. Now, of course, we know it wasn't vacant lands. The land that Columbus first, landed on in his misguided voyage or attempt to sail to India, it was clear that there was people there, and the atrocities that he committed against those people was all done in the name of Spain, but with permission, and actually more than just permission. I would say the will of the church at that time, and of course I'm talking about the Catholic Church, the Vatican, but it wasn't just the Catholic Church. It was the Protestant churches as well that would step up to this, but it was their view that if it took killing people to spread the gospel, if it took killing people to convert them, then it was worth it. That was a good trade off. So the idea of taking this idea of promoting your religion beyond preaching, beyond missions and missionaries, but actually promoting your religion with a sword, all of a sudden that that became appealing to the Catholic Church. But I say all this stuff because one of the earliest comments or what I would call an affirmation, the affirmation section in the preamble of this UN Declaration on the Rights of Indigenous Peoples, puts the doctrine of Christian discovery completely in the perspective that it always should have been. So let me read. This is the what is the third affirmation, and to me, it is among the most relevant passages or statements in the entire declaration. So it says, affirming further that all doctrines, policies, and practices based on or advocating superiority of peoples or individuals on the basis of national origin or racial, religious, ethnic, or cultural differences are racist, scientifically false, legally invalid, morally condemnable, and socially unjust. I mean, to me, that one statement says a lot. Again, it says that policies like the doctrine of Christian discovery are racist. They're scientifically false, legally invalid, morally condemnable, and socially unjust. Now, so the problem with making such a broad statement is, okay, if a policy or a doctrine, policy, or practice is deemed by the international community to be legally invalid, then what about the laws that have been based upon that? See, this is one of the challenges that the United States and and Canada and New Zealand and Australia had, because the foundation of many of the laws was that doctrine of Christian discovery. That's how they have asserted jurisdiction. That's how they have laid claim to land title. So at the foundation, and I would say for the in the U.S., the foundation of Indian law, or what they call Indian law, which is really laws about Indians, the foundation of that all goes back to this doctrine of Christian discovery, which is really the doctrine of domination. It is the doctrine that asserts that the Christian nations of Europe had the right, the God-given right, as they would prescribe, to dominate and subjugate people who were not like them. And of course, this turns into not just about beliefs, spiritual beliefs or religion. It turns into race, because clearly the Christian nations of Europe were white. And of course, the lands that would be discovered by these Christian nations of Europe were brown or black people. So it becomes not just a question of beliefs, because let's be honest, among the early things that Columbus and some of the church folks that he would bring along on his voyages did was to convert the natives, and that didn't stop the atrocities. So even as Native people became indoctrinated with this religious belief, and of course that was no easy chore, because the first thing you had to do was convince a people that everything they thought of, everything they knew, everything that they lived by for thousands of years was now wrong. In fact, it wasn't just wrong, it was sinful. It was the work of Satan. And this is what was, forced upon Native people. And when I say Native people, I'm not talking about half a dozen here. We're talking about 100 million people, perhaps hundreds of millions of people throughout North and South America. And certainly when you start talking about, in nations of Africa or in Australia, New Zealand, I mean, you're talking about millions and millions of people who were subjugated under first under the sword and the church, but then that subjugation would stay in place because it didn't matter. Because let's be honest, many slaves were Christians. They were the first thing that they were beat up over was adopting the Christian belief systems. All of South America, I mean, many of those countries would become devout Catholic. I mean, even today, as we talk about immigration, part of the challenge, for people who immigrate from South America is the challenge of and even as they're sorted out politically here in the United States, many of them are devout Catholics, which would lean towards the right, towards the Republican views. But because they're brown people, their best interests are oftentimes lined up with Democrats. It becomes very, very confusing. But this whole notion that a people can be subjugated first and foremost by their belief systems, would turn into something that would separate people simply by color. And that's why the importance of this affirmation. And I'll read it one more time because it's important. This is one of these quotes that should roll off of people's tongues. But let me read it again. Affirming that all doctrines, policies, practices, or all doctrines, policies, and practices based on or advocating superiority of peoples or individuals on the basis of national origin, racial, religious, ethnic, or cultural differences are racist, scientifically false, legally invalid, morally condemnable, and socially unjust. I mean, listen, folks, we've got white supremacy issues that are in the news today. So even though this thing was passed 10 years ago, and this affirmation was a part of trying to lay a foundation for Native people to no longer be subjugated or subject to genocide and assimilation, and it specifically lays some of that stuff out, and we'll get into it a little bit more. But in the United States, there's a president who sits in the White House who affiliates himself, even when he says otherwise, he affiliates himself with the Ku Klux Klan, with white supremacy, the alt-right. I mean, he stands, with white supremacists. White supremacists are a part of his political base. So this notion that that the entire global community, the international community, would condemn policies that would advocate superiority of peoples is missed by a large segment of American society. Now, and like I said, of course, in 2007, the United States, Canada, New Zealand, and Australia voted against it. Now, since then, they and I don't want to say they've endorsed the agreement, because what they've done is they've endorsed it conditionally. Both the United States and Canada have used almost the identical kind of language. They said, well, we support the aspirations of the agreement. So that's like saying we support the idea of people being free, but we're not going to see to it that people are free. We like the idea of it, and which is kind of what existed in the United States in the run up to when they finally, when slavery was finally, outlawed. I mean, there were many people who supported the aspirations of, of abolition, but who wouldn't do anything to see it through. So that's what the United States has said here. We support the aspirations of the agreement. And then, of course, then there's the provided part. Provided it does not conflict with U.S. law. Provided that it doesn't conflict with the United States Constitution. Well, that's the point. The whole point of making a declaration in the international community like this is to say, look, there are nations whose laws, again, getting back to that third affirmation, whose laws have their foundation in something that we consider illegal. So, I mean, for Barack Obama to say that he supports the aspirations of the agreement, provided it doesn't conflict with U.S. law, of course it conflicts with U.S. law. The third affirmation says that the foundation of some of your laws are illegally invalid, morally condemnable, socially unjust, racist, scientifically false. I mean, so there's a real problem with how, again, policies, practices, language, words, even from Barack Obama, and forget about Donald Trump, but from the previous president, even as they tried to wordsmith and tried to improve their appearance, because clearly voting against this thing in 2007 sent a statement to the world. But in 2010 or thereabouts, when Obama, and I'll tell you, when Obama got elected into office, one of the things that they wanted to do was to re-examine the UN Declaration on the Rights of Indigenous Peoples. So there was an effort to have a series of consultations at the State Department to re-examine the United States' position on the UN Declaration on the Rights of Indigenous Peoples. And I actually went down to that. In fact, Ross, John, and we went down to Washington. We attended. It was 2 days. The consultation at the State Department. Well, actually, one day was at the State Department, and that was where federally recognized leaders, so the Indians that the federal government says are Indians, that leadership could show up. But many of us were let in the room, and I was among them. That happened on the first day. The second day was opened up to what they called NGOs, non-governmental organizations. So that meant everybody else who wasn't considered a federally recognized leader. And that part of the consultation took place over at the uh, museum, the National NMAI, the National Museum of the American Indian, as a part of the Smithsonian museums. So the Native Museum. It took place in that auditorium, and so I was there for that too. Now the interesting thing, there was just a lot of rhetoric that went around the room on day one. Some people patting themselves on the back for having been involved in drafting some of this stuff, and then there was more conversation about things like sacred sites and protections and that kind of thing. That to me, I have a hard time dwelling on a specific sacred site within native territories when all of our land should be regarded as somewhat sacred. Now, I understand battling for some place like Mauna Kea in on the Big Island in Hawaii because of what it is, where it is, and the lust for it. Because of they want to put telescopes up on the mountain. So I get that, and I'm not diminishing the value or the role that mountain plays for the Kanaka for the Hawaiian people. But when I heard people talking about places, general places of worship, like somehow those should be prioritized over other parts of our land. Yeah, again, it seemed like a lot of that fluff was involved in day one. But in day two, there was a lot of questions are asked, and I stepped up to the microphone as I do, and had I went on a pretty good rant, and I on at this consultation on the stage in the museum auditorium were essentially representations of all of the agencies, pretty much all the agencies that came to mind: the Department of Defense, the Interior Department, the Justice Department, you name it, Department of Energy. I mean, all of the agencies were there, not just ones that have direct involvement with Native people. Homeland Security, all kinds of agencies represented there. And then there was also representatives from the White House, Kim Teehee, who was the senior policy advisor to the White House, Jody Gillette, who would actually become the senior policy advisor to the White House, but was serving in another White House capacity. She was there as well. So all of this was taking place in the summer of I think it was 2010, and ironically, this would take place just before the Iroquois Nationals would be denied the right to travel to Manchester, England, to compete in the World Games on lacrosse. So there was this issue that wasn't even being brought up for the most part. I kind of brought up travel documents in my bit of a rant. But one of the things that kept being said over and over again through this consultation was the concern that the federal government had. There were two main concerns. One is, would this declaration change international law? And of course it doesn't. There's nothing in this declaration that hasn't been said already in the Declaration of Human Rights and so many other declarations, associated with ending racial discrimination. Much of it is just reiterated, from other documents. There's a few specifics, and I'll talk about that a little bit. So that was the big question for the United States, and this is why they voted against it in 2007. Now the other question was, and they kept saying this over and over again. Our concern is this declaration might change the remedy currently in place to resolve disputes. And they kept saying this remedy, and it got said multiple times, the remedy for dispute resolution. So finally I asked the question, I said, what is this remedy you guys keep talking about? And they said, well, court. I said, so you're saying that your court systems are the remedy for conflicts with your government with Native people? You don't see a problem with that? You don't see a problem with there being no international, observers involved when you guys are committing an atrocity against Native people? You're suggesting that your courts can be unbiased? And let's be clear. Although the word sovereignty doesn't show up, well, it shows up one place in this UN Declaration on the Rights of Indigenous Peoples. It doesn't go so far to assert sovereignty. but it does talk about upholding um, the rights that have been guaranteed in treaties. Now, and I say, and again, it's careful to say not rights given in treaties, but acknowledged in treaties. And and the thing that has to be stated clearly, is, especially as it relates to Native people in the United States and frankly on the Canadian side. I can't speak for Indigenous people in Australia or New Zealand per se, but this would also go for again Ganaka Maoli in Hawaii. This there's never been a legal transfer of our sovereignty. So to suggest that your courts could rule objectively on issues relating to how your laws are being imposed upon Native people who never consented to that imposition is part of the problem. So there was just something, and there was again a an audible groan when I asked what they were talking about when they said remedy and they said court. I mean, there was a response from everybody there. So this kind of begins part of the problem because so if as it turns out Obama says, well, I support the aspirations of this agreement. Well, what does that mean? So if you support the aspirations, does that mean you still feel comfortable violating it? Because clearly they do. Because if there's one phrase that is that this declaration is known for, it is the phrase that it reads. I can almost go to any line here. It says, "Oh, well, the line is again free, prior, and informed consent. Indigenous Article 10, for instance, people shall not be forcibly removed from their lands or territories. No relocation shall take place without the free, prior, and informed consent of the Indigenous people." So that free, prior, and informed consent, it would be restated in Article 2 when it talks about redress. It would talk when it came to things like economic development. States shall consult further in good faith with Indigenous peoples concerned with their own representative institutions in order to obtain their free, prior, and informed consent before adopting and implementing legislative or administrative measures that may affect them. So even when, like tax policy, for instance, the according to the UN Declaration on the Rights of Indigenous Peoples, if something is changed, then the federal government has an obligation to obtain our free, prior, and informed consent. And that expression, free, prior, and informed consent, is laced through the entire document. So things like the floor tax that came right close to the same time, shortly after this thing. Um, this idea that they would impose travel restrictions if we would refuse to assimilate, and there's language in here about assimilation. If we refuse to assimilate by getting a U.S. passport, that's a violation of this agreement. And yet the week later, that's exactly what they would do. Article 8: the state shall provide effective mechanisms for the prevention of and redress for any form of forced assimilation or integration. By imposing state laws or imposing any state or federal law upon us without our free, prior, and informed consent is essentially forced assimilation and integration. By saying that we have to that we have to abide by state regulations or federal regulations in all cases, is integration. Any form, let's see, the state shall provide effective mechanisms for the prevention of any form of propaganda designed to promote or incite racial or ethnic discrimination directed against them. So when the governor of the state of New York stands up and says something like, the Senecas, they have a history of entering into agreements and then have non-compliance issues. That's a racist comment. And what does that do to the public? Especially when the media doesn't step up and say, wait a second, Governor, what are you saying here? When he's allowed to say things like that, or the media not only allows them, but allows them to go unchecked on statements like that, well, that's part of the problem. And you know what? These are violations of the UN Declaration on the Rights of Indigenous Peoples. I mean, I can go through this thing. I mean, altogether, as I said, there's only there's 46 46 articles here. It is only, by the way, the um, the 46th um, it's the 46th article that mentions the word sovereignty, but it's not ours. It says, and I'll read it for you. It says, nothing in this declaration may be interpreted as implying for any state, people, or group of persons any right to engage in any activity to perform or to perform any act contrary to the Charter of the United Nations, or construed as authorizing or encouraging any action which would dismember or impair totally or in part the territorial integrity or political unity of sovereign independent states. So the only time the word sovereignty or sovereign is mentioned in this declaration is when they say, look, we're recognizing your rights, but we aren't going to recognize your ability to reestablish yourselves as full-fledged sovereign nations because that what might interfere with the territorial integrity. Well, let's be clear. The United States, many of these countries have no territorial integrity. When, and again, as per the third affirmation of the document, if their territorial integrity is founded on something that this declaration starts from the beginning by saying that's that's racist, that's legally invalid, morally condemnable, scientifically false, and socially unjust, which is exactly what the doctrine of Christian discovery is, then that's where some of the problems are. All right, hey, we're at the bottom of the hour. Let me go out with a with a Murray Porter tune, and we'll take a little bit of a break here.
Can't you hear the babies crying? Can't you see the parents trying? Give a child a better life. He works an honest day for his honest pay. Still can't see you get ahead. Stay on that straight and narrow path. Don't give up now. How long can it last? Yeah, the time will come. You know the time will come, baby, when nice guys don't finish last. When the good don't die, yeah, you know the time will come. Time will come. Say that your heart is cold, been hurt so many times before. Don't turn your back on precious love, 'cause there's somebody walking around feeling just like you are now. They ain't gonna come through your front door. Open up your heart and don't get down. What goes around will surely come around. Yeah, the time will come when nice guys don't finish last, and when the good don't die, oh, oh no, no, you know the time will come, the time will come.
All right, thanks for coming back. Hey, I want to let me go to mentioning and thanking some of my sponsors here. I want to thank for those who've sponsored this show, not only as we exist today, but as we have existed for we're in our 8th year here. So I want to acknowledge Ross and Holly John and the RJE family of businesses, Eric White and ERW Enterprises, good friends like Ed Schindler, Tracy Brown, Cynthia Trice, Scott Snyder, Neville Spring, and my good friend Sugar Montour. I want to thank, as I mentioned, I want to thank those who have helped us in the past as well, because we wouldn't have gotten here, especially during those years that we were on paid programming on some of the commercial radios in Buffalo, if radio stations in Buffalo, if we didn't have the support from the folks who advertise. We're not an advertisement. We're not a commercial station. We are an internet station. So now we just get by with those who are willing to support the work that we do here, and that includes those who support me making the trip to New York each week, because I do a radio show in New York City, and that also is not commercial radio. It is it's community radio, WBAI in New York City, 99.5 on the FM dial. But those folks from this area and these friends that I've mentioned are the ones who make contributions, make donations that allow me to not only keep this broadcast going, allows us to do things like stream the video on Facebook and pay for the apps and the equipment to do all this stuff. So I've got to thank those folks. I also want to thank Unity Stream and Apache Radio Net for providing our streaming, and also thank CKWE for the simulcasts and the rebroadcasts of this show. And I also want to thank Netroots Radio, Real People's Media, and Indigenous Resistance Radio for carrying Let's Talk Native on their networks. And look, to all of you, and I've got to give props to my wife, because she's the one who probably shares this show via the Facebook groups is more than anybody. But any of you who check out the show, whether it's live or after the fact, and then share it, I thank all of you, because that is what is that's what gets the word out. The point of the show is to have a conversation and to perhaps enlighten some people on things they either didn't know, or perhaps they forgot they knew, or perhaps things that they were thought wrong. They were taught wrong, I should say. So, I mean, that's kind of what we try to do. And look, on any of the things that we talk about in this program, you don't have to take my word for it. Yeah, and I encourage you that if I say something that strikes you as either odd or possibly untrue, go to the internet, check it out for yourself. And you know what? Correct me if I'm wrong. Correct me if I say something, if I misstate something, and I'll if I'll retract it if I have to, but or I'll address it in such a way that people understand. Look, first part of the show, we did have some comments, and I want to respond to some of the comments. Yeah, those 4 presidents that were carved into Mount Rushmore. Let's be clear, that was just pure political propaganda. I mean, it was that project started in almost as a campaign promotion for Theodore Roosevelt. I mean, and the other presidents, the idea at that time to put Theodore Roosevelt in the same stature as Washington and Jefferson and Lincoln, that was a bit arrogant at the time. But that, and now when people look at it, I think people would still question, well, how did Roosevelt end up in that class of American heroes? And I got problems with all 4 of them. So don't get me wrong. And of course, the irony is that's in the Black Hills, a place that that was a complete illegal occupation. The United States, courts have acknowledged that. Again, not because they are the arbiter of justice by any means, because otherwise those faces would be off that mountain by now. But this is again part of the challenges that the UN Declaration on the Rights of Indigenous Peoples has. Look, a couple of other comments. There was a comment about the Pope. The Pope, to this day, none of the popes have officially retracted the doctrine of Christian discovery. I mean, and these, when I say that they were church doctrines, they were actually called papal bulls. These were statements or policies, doctrines that were put out in an official statement from not just from one pope, but from a series of popes, in that 15th century. And what would happen is there would be language or shifts in policies and so now essentially the position that the Vatican takes is, well, we no longer support the doctrine of Christian discovery. Yeah, you may no longer support it, but you still haven't repudiated it, which is kind of the point. I mean, there are folks who have talked to the lawyers from the Vatican and say, well, that's not really our policy anymore. Well, then say it. Then just say it. State for the record that the doctrine of Christian discovery has been repudiated by the Catholic Church. Other churches have done it, but the one the church that had all the juice to make this international law, and it is international law, In fact, even though this is church doctrine that comes out of, you know, the what is it, 1497 or something like that, or 1493, or somewhere right after Columbus's voyages, um, and then a series of additional papal bulls after that. And in fact, a papal bull or two before that. Even though it is out of the 15th century, in 1823, the concept of the doctrine of Christian discovery would be codified into U.S. law by Justice John Marshall of the Supreme Court, the Chief Justice John Marshall of the Supreme Court. He wrote in the opinions in the opinion on Johnson v. McIntosh, and made it very clear that Native people had no right to title. They simply simply existed as under the right of occupancy. And frankly, even that didn't hold up, because the idea of forced removal said that even their occupancy wasn't being respected. So forget about suggesting that that Native people own land. And this is again the contradiction, because on one hand you get John Marshall, who says things like this, that Native people had no right to hold title to land, and that their sovereignty was necessarily diminished upon discovery. Doesn't say why, just says it as a matter of fact. But even though he says that, it is clear that Native people did own land. Not only did they own land prior to forced removal, but even they would, the Osage would own their land, and in fact would live very wealthy lives that would cost them their lives because of oil being discovered on their lands in Oklahoma. There's no question that the Haudenosaunee, the Haudenosaunee, owned lands, and the United States, only a few years after 1823, or prior to 1823, I'm sorry, in 1794, in the Canandaigua Treaty, the United States would make it very, very clear that they acknowledged that we owned our land, and that the United States would never claim the same. And even today, it is very difficult for the United States to say that the Cattaraugus territory of the Seneca Nation, or the Allegheny territory of the Seneca Nation, or any of the lands, even the lands acquired, in Buffalo and Niagara Falls, it would be very, very difficult for the United States to claim that this land is theirs. Why? Because they have no foundation to make that claim. My good friend Ross John, he had a conversation with a bunch of law enforcement down in Allegheny one day, including the U.S. attorney, district attorney in the area, and he said, "You're not in the United States anymore. You're in Seneca land." And those guys took offense to that. And that's kind of where, again, the language in the UN Declaration on the Rights of Indigenous Peoples, there's a lot of good words in here. But the problem is we don't cite it. We don't cite the language. We don't force an Andrew Cuomo or Donald Trump or even a Barack Obama to say, yeah, we don't really follow that. And I say make them follow it. I mean, and I think in every dispute that we have with the state, with any state or federal or the federal government, any agency, yes, we should assert our sovereignty. And I'm not a big one on treaties per se, because the treaties don't give us anything. They may acknowledge something that pre-existed those treaties. But I think that's where we have to lay things on the foundation of sovereignty. So I think we should first off make our case for a state or federal policy violating our sovereignty. Then we make our case that they actually violate their own laws, state and federal laws. But I think we are remiss if we don't cite how they violate the international norms, the standards that have been established by the international community as a result of not just the UN Declaration on the Rights of Indigenous Peoples, but again, the UN Declaration on the Rights on Human Rights, and all kinds of other UN protocols. The language in here is very, very clear. But here's one of the things that that becomes problematic about how we interpret things. So when Barack Obama says something like, well, we support the aspirations of the agreement, and what does that even mean? And then if you follow that by saying, provided it doesn't conflict with our laws, well, so if your laws do conflict with the language, with the declarations, with the clear articles listed here in approved by the international community, then we leave you. Feel free to stand in stark violation of international norms, and that's currently what we have. So yeah, there's even language in here about redress and that kind of stuff, reparations and that kind of thing. And the United States isn't even close to considering anything like that. So the United States still today stands in stark violation. And we could cite example after example after example. Dakota Access Pipeline, Keystone XL Pipeline, any one of the pipelines that stretches through native territories. Any law that imposes their taxes upon us. What the state of New York is trying to do to the Senecas by extorting money and trying to call them out and force them into revenue sharing. Not only does it violate their laws, but it violates the language in the Declaration of the Rights of Indigenous Peoples. The fact that we are scrutinized or have our commerce interfered with, whether we do native to native commerce, the fact that the state and federal government interfere with that, our right to travel internationally, the fact that for me as a Mohawk or any Haudenosaunee to travel to another Haudenosaunee territory on the north of the imaginary line, the Canadian border, without a passport or an enhanced driver's license, the idea that they're trying to scrutinize us. And let's be clear, these travel documents that the United States is trying to insist upon, one of the requirements for something like a passport or an enhanced driver's license or even an enhanced tribal card, one of the requirements is that you declare your citizenship to either the United States or Canada. That's a violation of the assimilation and integration clause. This is how clearly and how starkly the United States violates this standard that has now been in place for 10 years. So, I mean, to say that you endorse the aspirations of an agreement, even in 2010 or 2011 or 2012, well, we're in 2017. And the United States is no closer. In fact, I would argue with the current moron in the White House, the United States is farther away from living up to the international standards as far as the rights of indigenous peoples go. I mean, as we sit here, we know that the Interior Department, the Secretary of the Interior, is looking at carving up ancestral lands for oil development, for resource development. Saying, oh, we could diminish this national monument. It's not really a national monument. It's just land that the Native people, hold sacred. I mean, it's amazing that this administration is even farther behind than the last administration. Because I got to tell you, I wasn't a fan. I got to remind people, the Dakota Access Pipeline, no free prior informed consent. That was Barack Obama's doing. Many of the laws, the PACT Act, the CHIPRO that would raise the federal excise tax and then create a floor tax for products sitting on a floor that was taxed at a previous rate. The United States went and they actually took $250,000 away from the Seneca Nation. They seized it from an account saying, well, we had a floor tax fee that we just took from you. I mean, there could be no clearer or more stark a violation of the UN Declaration on the Rights of Indigenous Peoples than stealing money from an account. So, look, I like much of the language in here, but again, part of the problem isn't just the United States' conditional endorsement of this thing, but there are some language issues and definitions. One of the things that the UN Declaration of the Rights of Indigenous Peoples is essentially all about is promoting self-determination. That right out of the gate is a big problem for the United States. Why? Because the definition of self-determination includes determining your political status. No, I don't. What does that mean? Well, it means that if you assert that you're still an independent nation, that's determining your political status. Now, the rest of the UN Declaration of the Rights of Indigenous Peoples doesn't go quite that far, but the definition, the international definition of self-determination, does include determining your making decisions for yourself, but determining your political status. The United States, early on, as this thing was being drafted, and this was coming out of the Clinton administration into the Bush administration. They had their National Security Agency draft a couple of pages that would clearly define how the United States would interpret things like self-determination, or even things like indigenous peoples. The United States wanted to reserve the right to determine who was and who wasn't an indigenous person, which is problematic not only because of what I call FedRec, because their definition of a federally recognized tribe is a tribe, band, or nation of Indians subordinate to the laws of the United States. Well, that just throws half of this stuff away because it doesn't support specific rights to indigenous peoples. It says, no, you're subordinate. That's what FedRec means. But they also wanted to redefine what self-determination means. And so what the United States said in their national security documents was that when we say self-determination, we don't mean the international definition of self-determination. We mean internal self-determination. We mean they can make some decisions in and amongst themselves. So in other words, their idea of self-determination was like a club. No, you can't assert sovereignty. And in fact, they made it very clear that they rejected the notion that an indigenous people could assert sovereignty over their own lands, over their own resources. I mean, that's in these national security documents. So the United States attempts to redefine international language. So the concern that the United States had about whether this declaration would redefine international law is maybe even more ironic or hypocritical when you realize that it's the United States who's trying to redefine international law. When they say, "Look, we're gonna tell you what we mean when we hear or when we use the expression self-determination," because when we say it, we don't mean the international sense of the word. We're far back from that. We're talking about, they can determine their membership, not even citizenship. See, they won't use language like, they can determine their membership. And even that becomes questionable because the federal standards would dictate that, if you just added people, we needed some verification that they are legitimate. So they don't even do that. And in terms of land, we still live in a circumstance where most native territories in the United States and frankly all of Canada the title to that land is not held by native people. Now that's not true out here in Haudenosaunee territory. The Senecas, their land is absolute title, is held in absolute title. The Senecas' land is the Senecas. It's not held in trust for them by the federal government, but that is the way most native lands are held. I mean, and in fact, the process to reacquire lost lands is called feed to trust. That means you take it out of state, fee title, and then you place it into trust, in federal land trust for your use and enjoyment. And that's how the United States defines quote unquote Indian country, this land that is being held for native people. So when the federal government talks about federal lands, they're talking about native lands because they're not acknowledging the distinction between the two, except for here. We, and not just Senecas, but the Haudenosaunee territories, with very small exception, hold direct title, absolute title to our lands. As small as they may be, as diminished as they may be, the small portions of land that we still retain of our original homelands, we hold in absolute title. It's called, and they refer to it as restricted fee. That restriction being that if we ever wanted to get rid of the land, as far as the federal government is concerned, that only the federal government could purchase the land for the states or whatever else. That we couldn't sell it to another country. That's the restriction. Now, we never even agreed to that restriction, but that's not the point. The point isn't we were going to turn around and sell our lands to Russia or China anyway. The United States has more problem with hawking its land to the countries like China than we do. But now we're 10 years after the passage of this thing, and the problem is we are no further along in terms of implementing any enforcement of this agreement. And I do, like I said, I do hold us somewhat responsible for that. Part of the thing is Native people are unfamiliar with the document. We're so familiar with the document, we don't know where to look. Even if we have a copy in our hands, we don't know where to look to say, let's see where the state is violating this thing. And every time we want to hold the state accountable, like I said, we cite our sovereignty and specific language associated with our sovereignty. We cite the violations of their own laws, and we should be citing the violations of this UN Declaration of the Rights of Indigenous Peoples. It's on us. If we want to give this thing force of law, we got to start using it a little bit more often. And so, even in this thing, in this battle with the federal government over, or with the state government over revenue sharing, let's cite how New York State is violating this thing. Call out Andrew Cuomo on this thing. Call out Donald Trump. Even as we get involved in the debate over or medical marijuana or cannabis dispensaries and that kind of stuff, there's language in here that says we have the right to determine our what we want to do for economic development, or what we want to do in terms of medicine. There's language in here that none of us are citing, even as we're waging war with provinces, with states, with Canada, with the United States. We're just not utilizing it enough. Now, I'm not saying citing an article in the UN Declaration on the Rights of Indigenous Peoples is a make or break citation. But if we don't get people more familiar with how the United States and Canada are violating this thing on a regular basis, then we're never going to get that international momentum. 'Cause, look, I understand the United Nations is a bit of a paper tiger. I get that. But what it still is, it's an international forum. Donald Trump's going to go down there and embarrass himself tomorrow, I think, in front of the UN. If I'm not, isn't that right? It's the General Assembly. Yeah. So you watch. He's gonna say something embarrassing, or he's going to post another video of hitting a golf ball off the back of Hillary Clinton or something. But so I mean, it does matter. It does matter to have an international forum, and we have this. What do they call it? The Permanent Forum on Indigenous Issues. We have this that meets every year in the spring. So there is an opportunity for us to raise issues. Here's the problem that I have with some of this and some of the UN. A lot of times the people who get to speak on behalf of Native people are some of the worst sellouts that we have. You don't hear the down to earth grassroots people and the issues that really affect people. Now, I'm not saying that there wasn't that the Dakota Access Pipeline and Standing Rock didn't gain some floor space at the Permanent Forum this past year. But why didn't it gain some floor space the year before that, or the year before that? This thing's been being built since Obama went to a flag waving ceremony out in Standing Rock, out in Cannonball, several years ago. We need to assert our presence at the United Nations. Not let some of these iconic individuals who have been, essentially blowing in the wind for decades. Look, I know some hard work went into getting this thing passed, and frankly, some shame, got heaped on the United States, Canada, New Zealand, and Australia to get them to at least offer their tepid or conditional endorsement of the document. Now the question is, can we call them out on it? We can say, look, this has been endorsed, even if it has been conditionally. But let's make it clear where the United States laws, where the United States policies, where they directly contradict the UN Declaration on the Rights of Indigenous Peoples. That's on us to do that. Nobody's going to do that for us. So that's kind of my point. So 10 years after the fact, maybe it's time for some of us to pick this thing up. You can download it off the internet. I've got a copy here from directly from the United Nations. I've got these little handbooks that the Indian Law Resource Center put together. I ordered 100 of these. I still have a bunch of these. Somebody wants a copy? Get a hold of me. I got a few I can still give away. But we should know this. You can find it online. Like I said, just look up UN Declaration on the Rights of Indigenous Peoples. This exact copy is essentially what's a PDF on at the UN site. But look at it, read through it, and when you're reading through it, think about the things that are being said on these in this declaration that you can clearly cite. New York State is violating, or the federal government is violating, or Ontario is violating. Quebec is violating, Canada's violating, Wisconsin, any of these, Michigan, um, North Dakota, Minnesota. I mean, let's bring many of these issues to the forefront, and maybe it's time for us to hold a specific conference on the specific citations in this UN Declaration on the Rights of Indigenous Peoples that the various states and the federal government are violating. Clearly, what the United States has been doing to Hawaii, again, not enough language. I mean, not enough citation on how much the United States is violating the UN Declaration on the Rights of Indigenous Peoples in any of our lands. So, on this, 1 week after the anniversary of the 10th year anniversary of this thing, I think it's time for us to pick it up and take a look at it. All right. Hey, I'll be in New York this week. Check me out Thursday morning from 10 till noon. And I'm going to have John Bauermaster on my show. He is a filmmaker, does a bunch of what he calls Hudson River stories. We're going to screen his films the following week in Brooklyn, his two short films, City on the Water and Restoring the Clear Water. So if you want to learn more about the Hudson River and the dangers associated with the fragility of that water, then check out my show in New York on WBAI.org. You can stream us there, or we'll be Facebook live streaming that show as well. So check us out on Thursday. Other than that, we'll see you back here on Friday. So thanks for listening, and we'll see you soon.